The Institute for Criminal Justice Reform, Icjr, has recommended to the government to impose a moratorium on death penalty prosecutions and executions due to the changing legal landscape post the new criminal code, KUHP Baru. According to a recent report released by Icjr, there are 509 individuals currently on death row awaiting execution in Indonesia. The issue of the death penalty has always been a subject of debate, including in Indonesia. The plan to implement Law No. 1 of 2023 concerning the Criminal Code, KUHP, in early January 2026 has garnered public attention. This is because the new criminal code will update the death penalty, allowing judges to impose death sentences with a 10-year probationary period, considering the remorse of the defendant, and with hopes of rehabilitation. If the defendant demonstrates positive behavior during this probationary period, the death penalty can be commuted to life imprisonment. Icjr, a researcher from Icjr, stated that based on the provisions of the new criminal code, Icjr recommends to the government to impose a moratorium on death penalty prosecutions, halt executions, and create implementing regulations regarding the process of changing death sentences, including for those sentenced to death before the new criminal code. Furthermore, Icjr also suggests to the Supreme Court to impose a moratorium on death penalty rulings and prioritize alternative punishments in criminal cases. According to Icjr, the prosecution and imposition of the death penalty in Indonesia throughout 2023 remain high and have been increasing over the past 5 years. From January 1 to December 31, 2023, there was an addition of 218 cases involving 242 defendants, with the majority being related to narcotics, reaching 89%. Based on data from the Directorate General of Corrections of the Ministry of Law and Human Rights of Indonesia received in writing by Icjr, as of October 19, 2023, there were 509 death row inmates awaiting execution. This figure includes 341 death row inmates involved in drug-related crimes. Additionally, there are 12 female death row inmates and 497 male death row inmates, with the majority also related to drug cases. Among them, about 110 individuals have been awaiting execution for over 10 years as of February 29, 2024. Icjr also added that based on nationality, 420 individuals, or 83%, are Indonesian citizens, WNI, while 89 others are foreign nationals, WNA. A broader humanitarian space. Professor Asep Nana Mulyana, serving as the Director General of Legislation at the Ministry of Law and Human Rights, stated that one of the substantial changes in the new criminal code is the regulation of death penalty as a specific type of punishment. Crimes that can be punished with this specific penalty include very serious or extraordinary crimes such as narcotics offenses, terrorism, corruption, and severe crimes against human rights. Asep explained that compared to other penalties, the death penalty is the most severe and should always be considered as an alternative to life imprisonment or a maximum of 20 years in prison. According to him, the formulation of the death penalty in the new criminal code provides a broader humanitarian space. The death penalty is imposed with a probationary period, during which the convict is expected to rehabilitate, so that the execution of the death penalty is not necessary and can be replaced with life imprisonment. Currently, the Ministry of Law and Human Rights is developing implementing regulations related to the death penalty in the new criminal code, which is expected to be completed by December 2024 for alignment and promulgation. Middle ground. Member of Commission 3 of the Indonesian House of Representatives, DPRRI, Taufik Basari, considers the regulation of the death penalty as a specific punishment as a middle ground in the death penalty controversy in Indonesia. He stated that this step is part of a new legal policy, where the death penalty no longer serves as the primary punishment but rather a specific one. Taufik also agrees with Icjr's recommendation regarding the 10-year probation period for death row inmates sentenced before the enactment of the new criminal code. Preventing torture. Deputy Chairperson of the National Commission on Human Rights, Komnas HAM, Abdul Haris Semendawai, hopes for support from the Ministry of Law and Human Rights to provide space for the Cooperation Team for Torture Prevention, KUHP, to visit places of detention for death row inmates. He emphasizes that keeping death row inmates on the waiting list for execution for 10 years can be considered a form of torture. Komnas HM also assesses that the death penalty is ineffective in combating extraordinary crimes, and there is no clear correlation between the death penalty and a reduction in crime rates.
There's a discussion about the pros and cons of the death penalty. So we will listen to the people. The recent poll that the government do is that 85% of the people remains pro the death penalty, considering the emergency situation that we are facing now.
The implementation of the death penalty in Indonesia has long been a contentious issue, drawing significant debate both domestically and internationally. Despite its intended role as a deterrent for the most serious crimes, evidence and expert opinions increasingly suggest that capital punishment is not an effective solution. One of the primary arguments against the death penalty is its lack of demonstrable efficacy in deterring crime. Numerous studies have shown no conclusive evidence that the threat of execution deters individuals from committing serious offenses such as drug trafficking, terrorism, or murder. Instead, crime rates often remain unaffected or even rise in jurisdictions where capital punishment is enforced. Moreover, the death penalty poses significant risks of irreversible miscarriages of justice. The legal system, no matter how advanced, is not infallible. There have been cases globally, including in Indonesia, where individuals on death row have been exonerated due to new evidence or re-evaluation of their cases. Executing an innocent person is an irreversible tragedy that undermines the justice system's integrity. From a human rights perspective, the death penalty is often viewed as a violation of the fundamental right to life. International human rights organizations, including Amnesty International and the United Nations, have consistently called for the abolition of capital punishment. They argue that life imprisonment without the possibility of parole is a more humane and equally effective alternative. The psychological toll on those awaiting execution is another critical concern. Prolonged periods on death row, often under harsh conditions, can lead to severe mental and emotional distress. This suffering extends to the families of the condemned, who endure continuous anxiety and grief. In Indonesia, the application of the death penalty has been particularly problematic due to issues such as corruption, lack of legal representation, and inadequate judicial processes. These factors further complicate the ethical and legal justification for capital punishment. There are also broader societal implications. The death penalty does not address the root causes of crime, such as poverty, lack of education, and social inequality. A more effective approach involves investing in preventive measures, rehabilitation programs, and systemic reforms that address these underlying issues. The implementation of the death penalty in Indonesia has been a subject of intense debate, both domestically and internationally. Despite being intended as a deterrent for the most severe crimes, evidence and expert opinions increasingly indicate that capital punishment is not an effective solution. Instead, a comprehensive and humane approach is needed to address the root causes of crime and promote justice. 1. Enhancing the criminal justice system. To address the issues within the current system, it is crucial to enhance the overall criminal justice framework. This involves ensuring fair trials, providing adequate legal representation, and eliminating corruption. Strengthening judicial processes will reduce the risk of wrongful convictions and ensure that justice is administered fairly and impartially. 2. Abolishing the death penalty. A key step towards a more humane justice system is the abolition of the death penalty. Life imprisonment without the possibility of parole offers a more humane alternative and allows for the possibility of rehabilitation. This change aligns with international human rights standards and reflects a commitment to the right to life. 3. Focusing on prevention and rehabilitation. Addressing the root causes of crime is essential. This involves investing in education, healthcare, and social services to reduce poverty and inequality, which are often underlying factors in criminal behavior. Rehabilitation programs for offenders should be prioritized, offering them a chance to reintegrate into society as law-abiding citizens. 4. Implementing restorative justice practices. Restorative justice focuses on repairing the harm caused by criminal behavior through reconciliation with victims and the community. This approach emphasizes accountability and making amends, rather than punitive measures. Implementing restorative justice practices can lead to more meaningful resolutions for all parties involved. 5. Strengthening human rights protections. Ensuring robust human rights protections within the criminal justice system is vital. This includes regular reviews of detention conditions, providing mental health support for inmates, and preventing torture and other forms of inhumane treatment. Upholding human rights standards reinforces the integrity of the justice system and builds public trust. 6. Public awareness and advocacy. Raising public awareness about the ineffectiveness and moral issues associated with the death penalty is essential. Advocacy efforts can mobilize public opinion and garner support for abolition. Educational campaigns and dialogues involving civil society, policymakers, and international organizations can facilitate this change. In conclusion, the death penalty in Indonesia fails to provide the intended deterrence and carries significant moral, legal, and practical issues. It is not a solution to crime but rather a symptom of deeper societal problems that require comprehensive and humane approaches to resolve. The death penalty in Indonesia does not effectively deter crime and carries significant ethical, legal, and practical concerns. By abolishing capital punishment, enhancing the criminal justice system, and focusing on prevention, rehabilitation, and restorative justice, Indonesia can adopt a more humane and effective approach to addressing crime. This comprehensive strategy will not only uphold human rights but also contribute to a fairer and more just society.